Hello ladies and gentlemen, my name is Jennifer Hilal and I'm a county court judge here in Broward County, Florida. Today I'm going to discuss with you eviction cases and information that both landlords as well as tenants should be aware of. The eviction process begins with the filing of a complaint by the property owner. The property owner is also sometimes referred to as the plaintiff or the landlord in the case. It is important to note that a property manager can actually file the complaint on behalf of the property owner. However, authorization must be signed by the property owner, and this authorization must be filed with the clerk of court at the time of filing the complaint. This authorization will allow the property manager to act on behalf of the plaintiff, the owner of the property. There are usually three reasons why a property owner wants a tenant evicted. The first is for failure to pay rent. The second would be because either an oral or a written lease agreement has expired and the defendant has failed to vacate the property. The third would be because the plaintiff feels that the defendant has failed to abide by the terms of the lease agreement or breached it in some way. Once a complaint is filed, the plaintiff will be responsible for having the complaint served upon the tenants. The tenants are referred to as the defendants in the lawsuit. The plaintiff must serve both a copy of the complaint as well as a copy of the summons. The summons is a document that explains the lawsuit's procedures. The complaint is a document that explains what the eviction is about. Both of these documents must be served either on the defendants individually, through substitute service, or by posting on their front door. These documents can be served either through a private process server or through the sheriff's office. Because evictions fall under the summary disposition statute, an answer must be filed within 5 days of receipt of the complaint. If the defendant does not file an answer within 5 days, a default can be entered by the clerk of courts and a final judgment for possession will be signed by the judge after the plaintiff provides the judge with the complaint, the corresponding documentation, a copy of proof of service, as well as a non-military affidavit. A non-military affidavit is an affidavit that shows that the defendant is not an active member of the military. Once a final judgment is received by a plaintiff, the plaintiff can request a writ of possession be issued and have the writ posted on the property's premises. This will be done so through the sheriff's office. Once the writ is posted, the tenant must vacate the property within 24 hours or risk losing all of their belongings. The writ permits the property owner to remove the tenants and their belongings from the property with the assistance of law enforcement. On the other hand, if a tenant files a written answer with the clerk of court, a hearing or a mediation will generally be scheduled within a week. Now, if the eviction is based on non-payment of rent, in order to obtain that mediation or hearing date, the amount of rent that is alleged due must be paid in full into the court registry. Now, if the defendant disputes the amount of rent that is due into the court registry, the defendant must include in their answer the reason why they are disputing the amount that is due and put the remaining balance that they feel is due into the court registry. For example, if the plaintiff alleges that $1,000 is due and you feel that you've already paid $200 of that $1,000, then you would need to show the judge proof of a receipt that you paid $200 and put the remaining $800 into the clerk registry in order to receive a hearing. The next hearing would be a rent determination hearing to determine what the remaining balance is that is owed. When the defendant pays money into the court registry, it must be done either through a money order, a cashier's check, or through cash. The money order and cashier's check must be made payable to the clerk of court. The clerk of courts will not accept a personal check, and they will not accept a check that has been made out to the landlord. So it must be made payable to the clerk of court. At the end of the rent determination hearing, the judge will decide how much money is due, and the tenant must be prepared to place that amount of money into the rent registry within a matter of days. If the landlord accepts rent from the tenant during the lawsuit, the plaintiff also has a responsibility to deposit any money that they accepted into the court registry. The clerk of court will hold all money in the registry until a final hearing is set and a final decision has been made by the judge. Now, once rent has been deposited into the registry, The plaintiff and defendant will be required to attend a mediation prior to their final hearing. Mediation is extremely helpful. The reason why it's so helpful is because it allows the parties to come to a compromise. They may be able to work out a payment plan, renegotiate their lease, or even reach an agreement on when the tenant will vacate the premises. It is much more flexible than the court process, and mediation in eviction cases comes free of charge to you. If you reach an agreement, that resolution will be brought to the court after both parties have signed off on it. The judge will then sign the agreement, making it a binding contract. The plaintiff will be entitled to a final judgment without proceeding forward to a final hearing. However, if the defendant abides by the terms of the agreement that they've reached out with the plaintiff, then the case will be dismissed, allowing the defendant to not have to worry about potentially going to court and having an eviction on the record. Now, sometimes parties are not able to work out a resolution at mediation. If this is the case, and all money has been deposited into the court's registry, then the judge will give the parties a final hearing. For final hearings, all parties are required to attend. The final hearing is also known as the trial in the case. Now, all parties involved in the lawsuit, both the plaintiff, the landlord, owners of the property, as well as all of the tenants of the property, must be present for the final hearing. If the property owner is a business or a corporation, the plaintiff must be represented by an attorney at this hearing. Even though the law permits the property manager to act on behalf of the landlord and file a complaint, the property manager will not be able to represent the landlord at the hearing. Now, during the final hearing, which is also known as a trial, both sides will have an opportunity to present facts to the judge. This is the time that you would bring any and all witnesses that you have that you would like to testify on your behalf, as well as any and all evidence that you would like the court to consider. This evidence may include copies of rent receipts, payment ledgers, the lease agreement, or any notices you may have provided to one another. Now, sometimes people would like to introduce text messages and photographs into record. We would ask that you bring copies of the photographs as well as copies of the text messages to court with you, because the judge will not be able to just scroll through your phone and take the phone into evidence. These documents are actually going to be collected from you at the end of the trial and will be entered into evidence. If you have any witnesses that you would like to come in and testify on your behalf, and you need to subpoena those witnesses, you can go down to the clerk's office. They will issue you a subpoena, and they will help you execute that subpoena, either through a process server or through the sheriff's office. It's very important that you have these witnesses subpoenaed, because if one of the witnesses fails to appear at your trial or final hearing, there is nothing the judge will be able to do about it, and your case will have to proceed forward without that witness. Ladies and gentlemen, before I conclude, I'd like to go over a few very important reminders for you. Please make sure that all of your court documents contain at least one phone number on them. If you have alternate phone numbers, such as a spouse, a work number, relative, or friend, please include their phone numbers on the documentation as backup. We'd also ask that you include an email address if you have one. And please make sure that all of your phone numbers, email addresses, and case number is legible for the judge to be able to read. It's important to note that regardless of whether you have an attorney or you are representing yourself, you are going to be required to abide by the rules of evidence as well as the Florida Rules of Civil Procedure. You must educate yourself on these rules and comply with them. You are welcome to use the Broward County Law Library located in the main courthouse, or use the internet or other resources that may help you prepare. If English is not your primary language, you must bring your own interpreter with you. The judge will not be able to provide an interpreter for you, nor will they be able to appoint a court-represented lawyer to represent you. Evictions are considered civil matters, and neither party has a constitutional right to a court-appointed lawyer or a court-appointed interpreter. Lastly, please know that the judge is unable to give you legal advice pertaining to your case. So if you need legal advice, please hire an attorney, contact legal aid, or make sure you do your best to educate yourself on the law. I hope this information was helpful, and I wish you all the best of luck. Thank you.